Thank you, Pratik. So, as I was telling that earlier it was Design Act 1911, but after the TRIPS agreement, that act was repealed and was followed by the new act. This is the now you can see this is the very thin act, as I was telling, Design Act 2000, and it is consisting of 47 sections and 47 rules, and there is first schedule, second schedule, third schedule. First schedule is the fees, second is the list of forms, and third schedule is the classification of goods. So I'll let you go through the whole act very briefly. So, what is the objective of the act? The objective of this act is to protect the design which is novel, that is new, and which is having any aesthetic and which is appealing to the eye. So, those kinds of design which can be put on any industrial product can be applied to it, can be 2D or 3D. So, those can be protected by way of Design Act, but not it should not have any, I mean, structural or functional type of thing, like those will be protected by way of patents if they just have any functionality. So as I told you that this came into force on May 11, 2001, and it has replaced the earlier act of 1911. So, what is design is mentioned in section 2D. As you know that all the acts we will find that generally the section 2 is consisting of the definitions. Like in Patents Act also, when Pratik was teaching, he taught the section 2, and it comprises of various definitions of the terms which are used in the act. Similarly, in this act also, the section 2 is having a list of definitions wherein 2D defines the, so it is very easy to remember, D for design, and section 2D says the definition of design. So mainly what is the design? This includes any feature of shape, configuration, pattern, ornament, or composition of lines. So composition of lines also can be protected by way of design. Then colors applied to any article can be both 2D or 3D, as I said, and in the finished article it should be appealing to the, and judged solely by the eye. Just by viewing it you understand that this is a design. So only the eye has to judge that it is a design. Now, what are not design? What cannot be qualified as design? This is mentioned in the section 4. I have just picked the very important sections of the Design Act. And if, yes, yes, I should hide it. Yes, okay, okay. Hmm. Thank you. So now what? So we saw section 2D is the definition of design, and now we come to section 4, which is another important section, which says what cannot be qualified as design. I will just compare along with the Patents Act also. In the Patent Act, section 2. We had the definitions, and in section 3 there was list of non-patentable items. If anyone remembers, Pratik had given the lecture. Do you recall anybody who went through the Patent Act also?
Yes, ma'am. Section 3 talks
Section
about it.
3, yes. So you had a list of non patentable items. Similarly, here section 4 says the prohibition of for the registration of design. What cannot be registered as design? So those which is not new or original. So in IPR, the prime important thing is it should be novel. Novelty is very more at most important feature of any IPR, intellectual property, be it design, be it trademark, be it logo or patents, invention, anything. So similarly, design also to be registered, it should be new, novel, and original. Secondly, it has, if it has been disclosed to public anywhere in India or elsewhere, anywhere in the world, in any country, in tangible form. Tangible, what is tangible? Which you can touch. So, by way of publication or by way of use, in any way, if it is known to the public, then also it is barred from registration. Thirdly, if it is not significantly distinguishable from a known design or a combination of known design, so then also it is not registrable. It will not get registered. And fourthly, if it contains any functional aspect, if there is, I told you, it will go for patents. Or if it is having some scandalous or obscene matter in the design, then also it will not get registered. Now, what is the process? Very simple. Design as compared to the other IPRs, it's very simple process. You have to file an application and it gets examined automatically. Like in patents, every time we speak that we have to file Form 18 for request for examination, otherwise the application will not get examined. So, but in this case, we simply file the application and it gets automatically examined. Third is if there is some, and most of the times, I will tell you in 90% of the times, only there are formality issues if it is objected. Otherwise, in most of very few cases, there is a substantive, issue like a novelty issue or originality issue for the objections in the FER. In design cases, also FER is issued similar to the patents, FER, which is the first examination report. And then comes, and when we overcome the objections, the attorney files a response to the FER, as in case of patents here also, and then it gets registered and published in the journal. And most of the times, without issue of the FER, the application is registered and you get a certificate. Now, where do we apply for the design? So these are the relevant sections where you will find section 5233 and 34. And this is the address of Design Office Kolkata. This is the main office. Now, in this case, what happens, like in patents, we do the e-filing, and until and unless there is not an objection from the controller, like he requires some original documents, we will not submit it. E-filing is sufficient. But in this case, whenever you file, you do the e-filing of the design application, and it has to be followed by the original. We have to either courier or post it to this address, the Kolkata address, patent office address. What documents? Number one will be your original POA, wherein the applicant has given his signature on the power of authority, and along with a form 1. And if it is a priority case, a priority application, then the original priority document also has to be submitted to the design office. And the time period for this, like today we do the e-filing, suppose, and within 15 days from today, you have to post, that means it should reach that design office, Kolkata, the original documents. Is it clear? Everybody, can you follow? Anybody can answer?
Yes, ma'am.
Okay, thank you. Okay, so what we said that we have to send the original documents like power and priority document to the design office. This is the design office address. Now, how many types of applications are there? There are only two types of applications in this case. One is the ordinary application, wherein you have come up with a new design and you feel like it should be registered, so you file an application. Now, second type is the reciprocity application. In section 44 of the Design Act, you will find that wherever an application has already been filed in some other country, and then that application is entering India. So that time it is called a reciprocity application, and in that case we need to file the priority document. Priority, that means wherein earlier document was filed in other country. So, and the time period is such an application. The reciprocity application claims priority of an application filed previously in a convention country. Like in case of patents, we do that those are signatories of the Paris Convention are able to file the convention application. Similarly, here also the those are signatory to the convention application. They will file within 6 months from the date of filing in the. Suppose you have filed in UK, in last 6 months. So within 6 months, you have to enter India also. And this period is not extendable. If the date is gone, that means you cannot claim the priority. Now, who can apply? Now, that means who is an applicant? So, in this case, any person claiming to be the proprietor of the new and original design may apply for the registration. And the proprietor may be from India or from a convention country. Now, the proprietor may be the author of a design or a person who has acquired the design, that means by way of assignment, or who has developed by the author. And these are the some of the, or whom the design has devolved. So these persons can be, and but the most important criteria in case of a proprietor from convention country is that he will not directly file. Like, there are two persons who can file the application. Now one is the sole proprietor himself. He can also file if he has a digital signature or e-sign. He can himself also file. And second is whom he has authorized, like we people, if he has authorized agents, he has hired some lawyer, so those persons can file on his behalf. So but in that case, that address of the agent should be from India. Okay. Now, what should be the contents of application? So, as I told you, design application is very simple. I will show you one real example also, wherein we have filed the application and we have got the certificate also. But before that, we'll just go through what are the needs. So first is simple form one will be there, wherein it consists of the name of the applicant, his address, his nationality, then address of service, which patent agent is filing on his behalf, his address, his or her address, and then form one. And if it is a priority case, reciprocity application, then the details of priority application, application number, etc., country, etc. So I'll show you one form one also after this. And then there is a form 21. In anyone will answer me in case of patents, which is the relevant form for POA?
26.
Thank you, ma'am. Yes, form 26. So in this case, for design, it is form 21. Now, then another important thing which we have to file along with the application is the representation sheets. What are these representation sheets? This is the actual uh, what design. So there should be 8 specimen sheets, wherein like front view, bottom view, top view, rear view, perspective view, side view. In this step, all the views of the design, so that the design is very clear to the examiner, is along with a novelty statement that the novelty resides in such and such feature of this design, that is mentioned. So I'll show you a real example also after this. So that should be filed along with the and the priority document if it is a priority case. If it is an ordinary application, then the fourth requirement is not required. Now, power of attorney, as I told you, this is mentioned in the section 43 and rule 9, and form 21 is the relevant form. Now, as I told you, that a design application may be filed personally by the applicant himself, or through a patent agent, or through a legal practitioner. So, if the application is filed through a patent agent or legal practitioner, then he has to have the power of authority. Only then he will be acting on his or her behalf. So, and the general power of attorney is also anyone can tell me what is difference between specific power of attorney and general power of attorney? Two types of power of attorneys are there. Sometimes we file the specific power of attorney, sometimes there is general power of attorney. Anjali, you would try? Okay, let me answer. See, specific as the name suggests, that means this the applicant is authorizing the agent, that particular agent, for a specific task. Suppose for this particular application only he has given the right so that we can act on his or her behalf. And general power is suppose for a list of your all applications from that applicant, or uh, all other tasks. I mean, filing, then taking care of renewal, restoration, everything, or for the case will be taken care by the said attorney. So that can be general. And as specific is only for specific purpose. Only for the, suppose only for the part of he may make a mind that he will change the attorney after filing, so he will give us authorization of only filing. Or suppose he will give only for one case, and then the other case he is giving to some other attorney, so that will be only specific case, specific power of attorney. Okay. Now, priority document, as I told you, that it is mentioned in the section 44 and rule 2D and 15 and form 18. Now, here, what is form 18? Do not get confused with the form 18 of Patents Act. Patent Act form it. I am comparing these two because maybe some of you candidates are appearing for the patent agent exam upcoming, which is in January. So, in that case, now what happened that Design Act is also included in the patent agent exam only. So that time, don't get confused. In the design question, you write form 18 is the, request for examination. It will be wrong. In design part, form 18 is for extension of time. Okay. See, here what happens that a reciprocity application shall be accompanied by a copy of the design application filed in the convention country. So that also you have to submit, as I told you. Such copy should be duly certified by the official chief or head of the organization in which it was filed. And another thing, suppose the priority document is in another language. Suppose the priority country is China. So in Chinese language, the application was filed in China. Okay. Now within 3 months, that applicant is willing to enter India. So in India, he is filing. So he has to submit that original Chinese document along with a translation of that Chinese document into English, and we called it verified English translation (VET), wherein there is a certificate from a person who is knowing. He will write that I am well conversant with both Chinese as well as English language, and this translation is the true and correct translation of the said priority application number. This. Is it clear? Okay. So that document has to be submitted. And if the priority was not filed with the application, the same may be filed. Suppose sometimes at the time of filing of the application, the applicant is unable to provide the priority document. So he has 3 months time, wherein by way of filing form 18, we can extend the filing of priority document for 3 months. But beyond that, it is non-extendable. So this is form 18 over here. Now, who is the authority involved? So everybody knows that this is PDCG. CG means Controller General. PDTM means P for Patent, D Design, and TM Trademark. So it is the Controller General of Patent, Design, and Trademark who is the authority on whose signature the certificate will be issued. Now, this is Locarno classification. Like in patents, I don't know whether Pratik has mentioned, it is the IPC. IPC is International Patent Classification, which we follow. And then in case of Kunal's lectures, trademarks, it is which classification he was referring? Nice classification. Okay. Similarly, in case of design, we have a worldwide which is acceptable, which is called as low Carnot classification. And in our act also, in the third schedule, you will find this list of 32 classes. So this the present Locarno classification contains 32 classes and 237 subclasses. Now one or two classes I will read for your better understanding. Now what is this? Suppose class class 1. See here. Class 1 is for foodstuffs. Foodstuffs including foodstuffs for human being, foodstuffs for animals, and dietetic foods. So within that there will be subclasses. If you can, is my book clear to all of you? Here you can see 0, 1, 0. These are subclasses. These are subclasses means now within food there are so many types like bakers, product, fruit and vegetables, cheese, butter, butchers, meat. These are another subclassifications under the class 1. Similarly, for one or two more I would like to quote here. Like Class 7 is for household goods. Then class 6 is for furnishing, furniture, set of furniture, etc. So in this way, there is a classification. So when we fill the form 1 in case of design, you have to mention which class and which subclass you are referring to. Now, the duration of protection is initially for 10 years, the certificate has been granted, and further you can renew it for another 5 years. Now, what are the rights you can say? Or copyright in design? What are the rights of a registered proprietor? These are mentioned in the section 2C, 11, 22, and 44. So it provides the exclusive right, like in case of patents, you get an exclusive right to stop others from selling or manufacturing your product. Similarly, here also, the proprietor of design gets exclusive right to apply the design to the article in a design in which the design is registered. A registered proprietor can institute a suit for injunction. This is very important. Like in case of trademark, do you remember Kunal must have taken what is the difference between passing off? Have you heard of what is passing off?
Yes, ma'am. When trademark is not registered, but it need protection, then we use doctrine of passing off.
Correct, very good, Anjali. But what is the benefit of the person who has applied and who has not applied? I mean, what is the difference? One very important difference.
Ma'am, if trademark is registered, then if anyone infringe, you get legal rights under section 29, I guess. But if you don't apply, then you don't have legal rights. Then you have to prove it in. It is difficult process how to prove that you have public.
Very good, correct. So similarly here also, what right you get if you apply for a design? If you don't register a design, you're simply using it, then you have no legal right. Na? But here you can sue another person if you see that he is cheating or he is copying your rights. So you have the rights for filing a suit of for infringement. Civil suit can be filed in that case. So, and you can also recover by way of damages. Similarly, in case of reciprocity application, the registered proprietor can claim damages in only from the actual date on which the design is registered in India. So these are you can protect yourself from piracy and you can also recover by way of damages. So these are the rights. So at present, legal remedies include injunctions, penalties up to 25,000 to 50,000 for repeated infringement, and the lapsed design can be restored within 1 year from the expiry. By there is a formal application which we have to file to get it restored, and one can also get the application cancelled on grounds of prior disclosure or lack of novelty, etc., originality. Now the difference with the design versus patent is for how many years?
Patent is
20
for
years.
20 years.
Very good. Patent is for 20 years and design only for 15. That too 10 plus 5 extendable. And uh, patent is for functional aspect and design is only for aesthetic, only for look. देखने में बढ़िया होना चाहिए. Design versus trademark. In this case, design again the product appearance, whereas the trademark is the brand entity. So design can't be used for distinguishing goods. Versus copyright. So copyright, all of us know, it is an artistic work, whereas design is applied to an article. Design registration excludes copyrights. So benefits, as we discussed, you can have legal enforcement and a commercial monopoly over it. So these are some of the very well-known design: Coca-Cola bottle shape, designer furniture, so many other. Then the international design systems are Hague Agreement, which is not India, is not a part yet. And then there are some more USPTO TRIPS Agreement, which we are following. We are following, and this is the office in design office in all the four patent offices, and the main office is Kolkata. Fees and form. Okay, now I will let you go through the. Uh, I just show you one.